Welcome. I'm Chris Colvin. I'm the founder of PARC, and we're a community for in-house counsel, outside counsel, and legal technologists to come together, network, share best practices, and help each other achieve more in our careers and to do a better job on the legal projects that we all handle. And we periodically have experts from both within our community and outside of our community come and speak on topics that are relevant to our members and to our guests. So thank you to those of you who are here live or watching this recording later. Today we have a really great topic around IP monetization of corporate intellectual property. And we have an amazing panel of very knowledgeable speakers here. We have Jeremy Pitcock of the Pitcock Law Group, and we have Dave Stevens of the Stevens Law Group. And I'll ask each of those gentlemen to introduce themselves briefly in just a minute. I just want to frame today's discussion. I've been an intellectual property lawyer and litigator for 26 years, and I always place sort of corporate IP assets into three tiers. I think, first of all, about number one, the known and monetized IP assets of the company. That's the most valuable. You have the orange, you squeezed it, you're getting some value out of it. Maybe you can extract some more value, but at least it's a known quantity and you've started to monetize that asset. Secondly, you have the known but unmonetized IP. So it's sitting on a shelf, you're aware of it. Obviously, you want to move it up that value chain to more monetization, but at least you've got your arms around it. And thirdly, you have the unknown and unmonetized IP assets of the company. And the real job of an in-house IP lawyer, from my perspective, is to move assets up that value chain. And luckily, both Jeremy and Dave are experts at helping companies achieve that. So without further ado, first Jeremy and then Dave, would you just introduce yourselves to the people here today with us and watching on the video so they know a little bit about your background and about the work you do in this area of IP monetization?
Sure, thanks, Chris. I have been litigating IP for 20 plus years. I started at large firms where I did a lot of plaintiff and defendant side work. Then I moved into private practice in 2008, did almost exclusively plaintiff side patent work. And particularly over the last few years, as generally the US patent law has changed to become more defendant friendly and less patent owner friendly, I have been working with an array of litigation funders to try to help companies take their IP assets and move them from being lower down passive investments on the Chris's food chain and to try to generate value out of them at no cost to the companies which own the IP, and have been very successful in sort of marrying together. I don't act as the attorney in these matters. I usually hire outside counsel, which specializes in plaintiff side intellectual property enforcement, get them involved with the funder, and then come to an arrangement for non-recourse funding for their patent portfolio. And that can be split out in a number of ways, but generally it's in return for a percentage of the profits that the IP generates through enforcement.
Fantastic, thank you. And Dave, would you like to introduce yourself?
Yeah, I've been building and managing patent portfolios for about 30 years for individual inventors, startups, big companies, and supporting important guys like Jeremy Pitcock when they go to war. Always in the rear with the gear, and doing it for a very long time, working closely with Jeremy for probably the past, I had to count back, 12, 13 years. Yeah.
Excellent, fantastic. Well, thank you guys for that introduction. So let's jump into it. First of all, let's try to frame sort of the IP monetization world a little bit. My background is sort of broad-based IP litigation, everything from patents, trade secrets, false advertising, trademark, copyright, et cetera. When we're talking about the IP monetization world, Jeremy, could you describe both, where do patents fit in and where does sort of everything else fit into that in terms of the ripeness and the degree of development of the market? If you can sort of make that clear at the outset.
Well, there are a lot of forms of litigation generally that have been fairly well developed, particularly general commercial litigation, arbitration funding. Within the intellectual property world, patents, in part because of the strict liability for infringement, you don't have to prove that a person knew they were infringing or knew they were doing anything wrong in order to get damages, tend to be the most well-developed area for litigation funding within the IP world. You do occasionally see trade secrets monetized as well, particularly as part of patent litigation enforcement. And every once in a while, you'll see copyright or other areas, but by far, most of what you see in intellectual property is patent enforcement litigation.
So in terms of outside funding, so funding by someone other than the ultimate client or the owner of the IP, is it fair to say that the market for funding patent litigation is far and away the most well-defined and developed in terms of that funding market?
For intellectual property, yes. I would say by far it's the most well-defined. Most funders have experience funding intellectual property litigation, patent litigation in particular. They have a system in place. They usually have experienced diligence counsel who know how to evaluate the case from an infringement, damages, and validity standpoint. And so they're usually able to, assuming that you've done all the necessary background prep, evaluate those cases relatively quickly and make a decision on whether to go forward with a funding agreement or not.
Got it. So if I'm let's say I'm a GC or an in-house counsel at a company with a substantial patent portfolio, how do I get started, Jeremy, and then Dave? How do I get started with sort of investigating whether I have underutilized patent assets that I might be able to monetize through third-party funding?
So, I mean, and Dave can be a big part of this. Your patent prosecution counsel or patent prosecution counsel generally, your in-house engineers, anyone who can look at the market and at least start to figure out the question of, are any of my competitors using my patent claims, is the place where all of these start. You need to identify, in order to have a funded case with a high probability of success, at least in getting funding, you generally need at least 6 or 7 patent assets, preferably from different families that read on competitors' products. And so, until you have that, and most people would prefer to do 10 or 11 or 12 in case some would drop out for other reasons. That's really the first place to get started.
Right. And Dave, what's your perspective on sort of how do in-house counsel and perhaps also the outside counsel that assist them, how do they get started in this sort of IP funding and monetization framework? Like how do they get off the dime and start generating some new revenues for their company?
Yeah, well, timing is always critical of getting started, and thinking about this from the very origin, your first patent application you file. It should be part of the process where when you draft a patent application, you draft claims, and there's different ways of doing things, but you want to have it in mind that you're possibly, and the most valuable patents are the ones that other people infringe, right? So
Right.
they're not just protecting what you do, the very specific, your process type of things, right? And you want to be aware of competitors from day one, as much as you can see. So for example, if you had a database technology that you're patenting and you're looking at, into the future, you might try to consider, well, if Oracle was to do this invention, was going to practice, how would they do it? It would be different than Snowflake, right? And all these different things, and you could draft claims with that ecosystem in mind. Those are the most valuable ones. But what typically happens is a company comes to us and wants to monetize their portfolio. We do a triage, right? Which is really an audit. It's an audit of the patent portfolio. What have you got? We look at the claims first to see, get some ideas from the clients, but we really need to do our own research and look around and see who's practicing these things. What's most valuable, the scariest patent portfolio, the most monetizable one, is one with pending applications, right? A lot of companies don't like to invest into a continuing patent practice. And for those listening, that's, when your patent gets allowed after it's been filed and it's been examined, before you pay the issue fee, you file a continuation with another set of claims. And the most valuable ones, you can't always tell early on, but you want to try to keep some applications continuing, so that when a guy like Jeremy looks at these things, he looks at these claims, they may not be perfect, and you can perfect them. You can even make more narrow claims that read directly on companies that are more, that are tighter and more difficult to invalidate. And you keep that factory alive, producing patents, right? The worst patent portfolio are the ones that are just fully issued, nothing left to continue. There are ways of reopening some of them, but that's another issue. But that's really what the timing is all about. And what we do is we'll do the first triage. We'll look at the claims very plainly and look around and find infringers. And it's always good to have a couple sets of eyes on these things, especially something like Jeremy, who has litigation background. Hand him these claim charts, something to review and to question every single one of them. And that's where you really understand the value of the patents. Do you have a clear read on infringement? Is there good support in the patent application? Are they well written? And that's usually a pretty quick turnaround per patent of this initial first look.
Right. Now, you made at least two great points there, Dave. And I've had discussions with both you and Jeremy about sort of the interplay between patent prosecution and patent litigation. And I think whether you're dealing with a client funding the patent litigation themselves, or a contingency where the eventual outcome funds, or a third-party funding, which is what we're talking about today, really in all three areas, the most valuable patent families are those which have two characteristics. One is the breadth of the claim family, the legal description of the invention for those that aren't patent lawyers. That should be broader than what you're actually selling as the corporate owner of the IP. You should think about people trying to design around, and you should think of covering the ecosystem, as Dave said. So that's one critical concept that really contributes to the ultimate monetization of the patent family. The other concept is, I think of it as always having an open patent application. And one thing that I think people who aren't patent lawyers, it sort of takes them a while to wrap their brain around this. After you've identified an infringer, you can actually craft claims that read on the device or the system that you're accusing of infringement, which is perfectly okay as long as the specification supports adequately supports that claim. So the patent prosecution in some ways never ends for the most valuable family of patents. And that's an important concept for those in-house lawyers and others that are involved in some respects with trying to monetize IP assets, but maybe aren't patent attorneys themselves. So there's a role for someone like Dave, there's a role for someone like Jeremy, really once you're heading into a litigation. So I also want to switch gears here and ask Jeremy about how do you, Jeremy, help companies? How do you specifically work? You mentioned both working with corporate clients that have patent portfolios and also working with outside counsel. Can you describe how you work with companies, and maybe without naming any names, describe some of the successes that you've had in working with those two groups to sort of find it. Bottom line is find additional revenue for the company.
So the success, well, first of all, the first success is getting the case funded so that they can attempt to monetize the IP. And then, of course, there's the ultimate, how much money did you make at the end of the process?
Right.
So in terms of what I do to try to get funding is after there has been a triage and there has been some analysis of the patent claims, is to go through that with enforcement counsel. You usually pick counsel that has specialized expertise in whatever area it is that the patents are in. So if it were databases, you'd pick a firm that had a lot of experience litigating databases. You would also have to do some triage in terms of damages. Is the product sold a lot of? I mean, you can make mistakes. Just because the product is infringed doesn't mean that there's enough of a market base to make it worthwhile to go after. And then after you go through that, you also start to look at venue, because in patent cases, that can be very important. In ways, a company that you can sue in Texas is more valuable, at least initially, than a company that you can only sue in the Northern District of California, just because, there are different districts that tend to be more hostile towards patent claims than others. And there's a time to money. I mean, the longer it takes for you to get to a settlement, the more expensive the money is that you borrowed. Just like any loan, there's an interest component to almost all of them. And so you are also wanting to try to pick a jurisdiction where, in East Texas right now, if you're in front of Gilstrap, it's 14 months to trial, and it could be 4 years to trial in the Northern District of California without it being, much of an outlier. So, those are all important considerations. And after you've looked at all that and you've chosen counsel, they usually will work up the case and take a preliminary look at all those issues, damages. When I work with them pretty closely to make sure that what they're doing is in line with all the other cases, that I've seen. You want to be very conservative and reasonable when you're approaching funders. And then depending on how the case looks and how much money you're asking for, you would then put together essentially a memo, an executive summary of the case, and you would send it to, sometimes one or more. I tend to operate more serially, where I go from one funder to the next and see if they're interested. The next step is usually you sign a period of exclusivity so that the funder, they do their own diligence, the kicking of the tires, and then at the end of that period, they will have made a decision whether they're going to fund your case or not. It's pretty typical for that to take 45 to 60 days, and for all the triage part of this to take a couple of months as well. So if you decide today that this is something that you want to do, it's probably going to take you 4 to 6 months to actually get to an up or down decision on litigation funding.
Got it. And because we only have about 5 minutes left, I want to cut to the chase on another question, because we're trying to keep this brief and save time for Q&A. I remember back in the day as a patent litigator, I spent a lot of time defending cases in Texas brought by the non-practicing entities, or some people call them the patent trolls, and that got some press attention even in mainstream media back then. But I want to understand how things have evolved. So back in the day, it was pretty clear. There were these non-practicing entities that would gather together these patent portfolios, and they would hire plaintiffs' counsel to sue, primarily in Texas, some other places as well. But they were generally not, there wasn't much in the way of a corporate entity doing other things, right? These were groups of patents. There was some type of entity that owned or licensed the patents, and then they would sue. But I think what you're talking about, Jeremy, to be clear, is an ongoing corporate enterprise that actually sells products and services and does other things. And this patent monetization is something else they can do. So how has the ecosystem evolved from that sort of bilateral type of situation I discussed to where we are today? And both, and I want to hear from Dave as well on this. How have things changed in, say, the past 10 or 15 years, and how do ongoing corporate concerns get involved?
Well, so I mean, in terms of venue, the biggest thing that's changed is Supreme Court precedent. For a long time, you could sue an infringer anywhere that they were selling products. And that got reversed a few years ago by the Supreme Court. They ended up finding that no, you had to have an office or some actual bricks and mortar place of employment within the district to sue a company properly there. So, and there has been a fair amount of case law, well, what if you have a server farm of 100,000 servers in East Texas? Is that enough to sue Google there? And so that area of the law keeps evolving, but for the most part, if you don't have some sort of office building or something, unless you're a foreign entity, you can't be sued in any district, or in particular the Eastern or Western District of Texas. The other thing that has happened is the Federal Circuit over the last, over the last year, in response to Judge Albright in the Western District of Texas refusing to grant any motions to transfer for convenience sake, has now issued probably more writs of mandamus, moving cases from Texas to an area where a company has their corporate headquarters in the last year than any court has issued a writ of mandamus for anything in the past 10 years among all the circuits. So, and including some very questionable decisions, or at least arguably questionable decisions, where, Apple, which has a huge campus in Austin, Texas, within the Western District, got moved to the Northern District of California, even though they were sued in the Western District of Texas. So that all plays a factor because mainly because of speed, right? So Texas just tends to be a lot faster. And then to some degree, when it comes to various defenses, which may or may not be important, like 101, subject matter, they tend to be less likely to grant motions to dismiss on those grounds. And then with the Eastern District of Texas, you have the added benefit of what are considered fairly plaintiff-friendly juries. And so most companies end up creating what's called a special purpose vehicle, which is basically an LLC that they don't operate, they don't do anything other than hold the patents for enforcement. And that's the entity that gets funded when they go forward, so that their own ties to California, New Jersey, wherever they happen to be primarily located, are not as important in the transfer analysis.
Got it. That's very helpful. Thanks so much, Jeremy. And Dave, I want to give you the last word, just from the perspective of the in-house lawyer who's trying to, do right by their company and try to activate maybe these unperforming or underperforming patent portfolios. what's your advice to those folks to how do they get started and get engaged with this process? And then also, how have you, Jeremy gave a very useful sort of historical perspective over the past 10 years or so. What have you seen and from your perch as a very active and longtime patent prosecutor?
Yeah, well, advice to the in-house counsel is start early and audit your patent portfolio. And there's a lot of reasons to do it. It's not just, and don't wait until you got the go ahead, hey, let's go monetize this, right? I mean, it doesn't cost much to audit it because it's really a bunch of internal questions and some review. So it's good to know what you have. You may be overspending on everything in your patent portfolio. You might be paying too much for your attorneys. You might be paying too much for maintenance fees, domestic and foreign. Often what happens, they get transferred to the finance department. They're called assets, just like building, and they keep paying them, right? And larger companies, more, I won't say sophisticated, but people who have looked at it more, they sell off patents that are not worth anything to them. And you can get money back for them. There are companies that need these things, that even if you don't, right? So having an active internal audit process periodically will show you what you have. So when you do, if you decide to enforce these things, then you'll have a good idea of what's valuable. And part of that audit is take a look outside. It doesn't take much to look. There's a lot of public information. In fact, that's what you have to rely on. Right. Look at public information, see if there's infringers, and say, hey, we rate them usually 1 to 5. So the 5s are the ones that other people infringe. The 2s and 3s are the ones that, well, maybe not quite yet, you see? And that will give them, this indicator of, at an ongoing basis, and these can change, right? Of what are valuable. Don't cut these, for example, right? Obsolete, and even things they might think are useless technology, no one's using, and those are the ones that you sell off or just abandon, right? Stop spending money on them. That's my best advice for them, because when the triage comes, you have what you have, and time's always your enemy, right? And you should also have a clear policy in place as soon as you can of continuation practice. Should we do it? How much of our budget are we putting into this? And you don't have to do all of them, but pick the key ones. Take the 5s, always continue those, right? But have somebody involved that really knows what they're looking at. It's a modest investment just to have that visibility, and that's what I think is most important to them. Now, over the last 10 years, I agree with everything Jeremy says. One thing that I've seen from the patent office, from the perspective of dealing with the patent office, is that examiners are more timid to allow broad claims, right? Because they get bad press. It means something to them. They get in trouble if they launch these broad claims and they go sue everybody, and then they show up with all this prior art and say, hey, these things should have never been allowed, right? And they care about that. So often what you see more, I've been doing this for about 30 years, it used to be easy to get a few claims allowed right after the first examination. It was very common. Now it's more common just to get them all rejected, right? They have less time to spend on them. Resources are pressed, it's a government entity, right? And they're chicken to allow, I'm nothing against them. they're afraid to allow broad claims, right? So what you want to do is apply for a variety of claims, from broad to narrow, and very reasonable ones, right? Get something allowed. And once you have a claim allowed, then you've got the examiner who's kind of bought into it. There's something new here. There's nothing new here. They can't reject everything. And that's when the continuation practice kicks in. Okay, we got this nugget. They said this is new. And they actually issue reasons for allowance when they allow a case. Read those things. Those aren't just for your patent attorneys. Look at those things. If they say, this is the reason I allowed it, and they give you a couple sentences, then take those and use those in broad claims. Sometimes they'll just say, well, this is novel. They just rewrite the claim. It doesn't tell you anything, But often they'll say, the art doesn't show this particular thing. Well, there you go, right? So it helps with practice. And more importantly, and you've heard me preach this before, patent attorneys, make them engage with the patent examiners, not later, right? I mean, even before they examine it. Nobody does this, by the way. We do it with every single case. We dial up examiners before we get our first office action. Strike up a relationship, help them. Here's some art. Hey, let me describe the invention for you. Look at these paragraphs, look at this drawing, and here's how I articulated it in claims. And you get that to the examiner, you streamline the process, you practically do their job for them. You'd be amazed what it does for you. It even cuts costs.
Right, that's great advice, because really you're framing the issue instead of the examiner framing it for themselves. You're saving them time and effort, earning their gratitude, and even more importantly, framing the issue. So you get to, it's now analyzed within your proposed framework, hopefully, rather than whatever the examiner might come up with. So those are great points. And I also take away your larger point, Dave, which I really think is important. And that basically goes to the fact that in this day and age, a well-run company, their intellectual property is one of their most valuable assets, if not their most valuable asset, probably more valuable than plant and equipment and everything else. And why would you not have a dedicated resource to take care of that and maintain those assets on an ongoing basis, right? Via continuation applications, via audits. This is something that should be, I think, in my view, and I think Jeremy and Dave would agree with me, this should be integrated into the legal department's practice. It should be part of your annual budget cycle, and you ought to have a line item for maintaining IP and continually improving it and monetizing it. And whether that resource is a dedicated in-house lawyer, whether it's an outside firm like Dave's, either way, or both, if you're a larger entity, it's really an important line item. And it's to end on a really, I think, hopefully an upbeat note, I think IP is one of these areas where the in-house lawyer can really be the hero, because they're helping the company to generate assets. And I think too often in-house counsel are thought of as a cost center, but here's a chance to be both a strategic resource and a source of potential additional income for the company. So I think it's really an area that, even if you're not an IP specialist, it's an area you should be knowledgeable about and should be able to help your company make more of the IP assets it does have. So we have to wrap up now, because one more point, Dave. Yep.
Yeah, just one point. I think think Sarbanes-Oxley IP. When Sarbanes-Oxley came out, there were a lot. In fact, I gave a talk on this one. Hey, Sarbanes-Oxley, look at IP. Never went there, right? Never went there because nobody wanted to go there because it was too complicated, right? But if you just put that same emphasis on that, then all the finance people understand it. The whole company understands it, and it just raises that level of urgency.
Great point. And finance is the language of corporate life. So, it's good to put things in financial terms. So I just want to, before we stop the recording, I want to make sure that the people watching later know how to reach both of you guys. So do you want to share, say, your website so people that have additional questions can get in touch? Jeremy and Dave, how do people find you?
Sure. So you can find me on my website, www.pitcocklawgroup.com, or you can just email me, jpitcock@pitcocklawgroup.com.
Great. And Dave?
Yeah, I just shared my website. It's stevenslawgroup.com, STEVENS, and call me directly, 408-316-5531.
Great. If anybody wants to reach me or learn about PARC, you can go to parklegal.org or chris@parklegal.org. So thanks, guys. I'll shut down the recording. Happy holidays to everybody. If you're here live, please stay, and we're going to do a little Q&A off the record, so to speak. So thanks, everybody. Have a wonderful and safe holiday season.